Legal affairs should be a money generating and a profit preserving tool in your agency. Um, it's nice and it's generous if you can get to the headspace of thinking of it as an investment, but most agencies don't even get there. They get to the this is a line item expense.
Welcome to the Digital Agency Growth Podcast. I'm your host, Dan Englander.
So today on the show, I am very excited to welcome back a friend of the show, Sharon Toerek. So Sharon is a marketing and intellectual property attorney who helps independent marketing, digital PR, and creative agencies protect their assets and turn their ideas into revenue. She's the founder of Torek Law, a law firm dedicated to marketing agencies. Before we threw on the recorder, I was like, this is the perfect length and it tells everyone what you do. And I appreciate that after reading lots of bios on the show. So thank you for that.
I think my words specifically, Dan, were any longer and we're gonna bore people, so we're good
Yeah.
enough right there. Yeah.
Well, it's funny you should say that because with legal, and I'm the son of a bankruptcy attorney slash litigator. He's like
I
well,
didn't know that. This is new
yeah,
information to me. Okay.
exactly, a
Okay.
40-year plus veteran. But I actually think so when you say law, people get bored,
Mm.
maybe alongside accounting, et cetera. But I actually think it's really interesting. I think there's a lot of opportunity to be had as we'll dig into, and there's a lot of places to go with it. So, I think a lot of people on our show probably know you by now, but would you mind kind of giving your high level intro for how you got into this line of work and working with agencies as a niche?
Yeah, I well, first of all, thanks for having me back. It's so great to be able to have the chance to talk with you again. So I founded Torek Law, which does business in the agency world as legal and creative, about a dozen years ago, almost 13 years ago. And I did it after I had spent some time. I'm an IP lawyer originally by training, and um, just generally gravitated towards marketers, mostly in the brand protection and the copyright realm, originally, but started to work with more and more agencies over time and really realized that there was not a lot of resources or help out there for independent agencies, especially agencies that are in holdcos usually have access to in-house legal, but independently owned agencies didn't really have a lot of options when it came to legal help brought to the table by somebody who took the time to understand their industry, which I was spending time doing, all along the way. And so I founded this firm specifically to serve independent agencies. And what I love about it is it blends a lot of my favorite things. It blends entrepreneurship, it blends access to creativity and innovation, and I love seeing the impact commercially, socially, and culturally that our clients have with the work that they do. And we get to have a front row seat to all of that, which is a privilege for us. So it's a reason why I love being in this space and why we love serving the clients that we do.
Yeah, and just like an agency experiences, it's rarely the same thing over and over again. It's probably lots of new challenges and so on. So, with that in mind, and from our previous conversations, you serve agencies in a few different areas, in contracts and IP protection, marketing regulation, compliance. So for those owners, they're like, all right, legal, this is just another box to check, another boring admin thing I have to deal with. Like, how do you reframe that as something that can actually drive revenue?
Yeah, it took me a while to really think about how to best articulate the way or my point of view about the role of legal in an agency's business operations. And really, it comes down to this for me. Legal affairs should be a money generating and a profit preserving tool in your agency. Um, it's nice and it's generous if you can get to the headspace of thinking of it as an investment, but most agencies don't even get there. They get to the this is a line item expense that we need that's gonna take away from some other thing we need to spend money on. If you think about it and the upside of being proactive about your legal affairs, not only can it help you reduce risk and therefore preserve more of the profit that you need to keep from the work that you're doing, but it can also be a revenue generating part of your operations, particularly in the IP realm, but in others as well. And so it's really kind of it's close to my heart and my mind that agencies think about this as a money-making function within their business operations rather than a cost drag.
Right, that makes sense. So let's dig into some examples. So maybe starting with contract negotiation and that phase specifically. You're let's say you're at the end of a proposal, you've gotten a verbal yes on it. You're now dealing with legal with a mid to large company. You're kind of thinking of it as this like speed bump between handshake and kicking off work.
Mhm.
In that moment, or maybe it's not a moment, maybe it's 2 weeks or something. What are agency owners leaving on the table by thinking of it that way?
I think that they're leaving, first of all, they're a much higher risk of agreeing to a term that could be disadvantageous to them down the road, financially, and some good examples of those are, yeah, we've agreed on the payment terms, and we, the agency, we like 30-day terms, but we're willing to agree to what the brand is demanding, which is 60, and we don't love it, but we really want their business. It's a good project or it's a good retainer and etcetera. But you're not going a step further and looking into the language that the usually an enterprise or a government, client is putting forward in their agreement if you're working off of their paper, which says things like, "We'll pay you within 60 days, but that time starts running after we approve your bill or after we're done disputing any of the charges that are in the bill." Or, after, and so 60 days becomes 75 days or 90 days or, you know, to the extent that you miss things like that, and hopefully, if you do, they're never an issue, but when they are an issue, they can choke an agency's cash flow financially. That's one example. Another example is, let's think about exclusivity requests from a brand. Let's say you're inclined to agree to some exclusivity terms in your agreement, and that's you've decided that's table stakes, right? For being able to do business with this client or to work on this project, to have this feather in your agency's cap. Are you premium pricing for that? You should be as an agency. And that is not necessarily as much a legal issue as it is a business issue, but it certainly will be reflected in your contract or your SOW that goes along with the contract. Are you narrowing down the exclusivity as much as possible so that you are you are agreeing to, and since we're talking to agencies, I'm just letting my hair down here. You are agreeing to the bare minimum exclusivity terms that will be acceptable to the client and give them the assurance and confidence they need that you're not going to go work for one of their biggest competitors in a product category that could do some damage to them. Um, and not being overbroad, like an entire industry or an entire set of product categories. Are you being narrow enough? Are you maybe limiting it to certain brands? Are you limiting it to certain brands and certain product categories? Are you certain that the exclusivity will expire as soon as you stop working with this client and not for 6 months or 18 months afterward? These are things that can all cost an agency financial opportunity. And so those are just 2 examples that come off the top of my head. There are others, but, IP is a whole separate area where you can be leaving money on the table by agreeing to something being a work for hire when really you need to be carving out some of the work that you're doing as an agency-owned asset because you may need to use it to deliver to another client at a later point in time.
Yeah, and I can see this issue has already been murky for a long time, and I think with the reusability of assets and AI, it's probably just getting even messier. And I think the ultimate like catch 22 is like so many agencies have been forced to specialize more in order to compete. And you don't have to just specialize vertically, but it's the most tried and true way to do it. And it's what clients need to feel confident, hiring the agency.
Right.
But it also means you have more of this exclusivity issue coming up. So to bring this to a question, I guess, like, how have you seen agencies sort of navigating that? There's situations where like there's a direct and real issue to the compete, like you have a geographic area and you'd literally be pitting one client against another with an ad campaign. And then you have others where it's just like what does this even mean? And you want us to have this experience, but then when we have it, we're punished for it because we don't have exclusivity. So I love to hear kind of how you see clients dealing with it.
I think a couple of things. I think, you have to really understand, and I gonna be the first to acknowledge that this takes upfront time that feels painful to agencies who are in a hurry to get that money flowing into the coffers of the agency, or whose teams, I mean, you're all excited, right? You wanna work together, you've agreed maybe on some concepts or some strategies, and everybody's, like, good to go on the marketing and the creative side, and, the lawyers and sometimes the procurement people are slowing everybody down, but you will never have more leverage as an agency than you do at this stage of the relationship, and so you need to be patient and plow through that, with intent, and so some of the things you can do that we've seen, some strategies that we've seen, are to truly take the time at this stage to understand the business objectives of your marketing counterparts. They are navigating, perhaps, especially if you're contracting with a big brand. Internally, they have their own dynamics and politics to be dealing with. An exclusivity issue that is being hammered, by their legal or their procurement may not actually be a legitimate competitive threat that their marketing people believe exists. And so having your marketing counterparts at the brand that you're negotiating with in the loop at all times during the negotiation of the contract is critical. I have had negotiations where it's clear that nobody on the brand side was talking to each other. Because once you got them all in the same room or on the same call, marketing would be like, "That we don't care about that. That's fine. We can strike that, or we can limit that, or we could be more narrow, or we can be." So, make certain you understand your clients' actual business concerns and goals. What's the threat they're trying to navigate around by asking you to agree to that exclusivity? And what are some creative ways we might be able to limit that are stomachable for everybody? And then have them help you and be your advocate throughout their organization. Some organization, legal and procurement people don't love this, to be candid with you. It's not a good reason for you not to involve them anyway as an agency, because it will definitely make sure that everyone's on the same page. And in my experience, it's made things go a little bit faster. So there's taking the time to ask the questions like, what is the problem you're actually trying to solve here by making this ask in the contract? I get it that it's part of your forms, but within the context of the work we are actually gonna be doing for you and of the business goals that you are saying you actually want us to help you achieve, why do you need this language here? Is it really relevant? Is it really a threat? Okay, if no and no, let's get rid of it because it's making us uncomfortable. So,
That
again.
Sorry, I was just gonna say that all makes sense. And just to dig into some more examples here, you mentioned the exclusivity thing.
Mhm.
Are there any other and giving that away too easily? Are there any other common mistakes that you see in contracts that are costing agencies money?
Yeah, I think one major one we see is that there is sloppiness, quite honestly, around the whole timing of the transfer of intellectual property in the agreement. We have actually been in scenarios where an agency's been able to use the leverage that they have because their contract handled it properly, by which I mean they didn't transfer the rights to the work until they'd been paid in full, which is how it should work and how your contracts as an agency should read. Um, and they were able to use that leverage to limit access to the assets they had created until they were actually paid. And it was high five figures, which to an agency of this size, it's a lot of money. So that's a case example that I can give you. Another mistake we see around IP is the failure to carve out any IP that the agency needs to hold back, as I alluded to a couple of minutes ago. You may be in the course of creating work for hire or deliverables for the client, come up with a system, a methodology, a piece of software, a content library, whatever it might be that is important to the agency to be able to hold the rights to because you're going to need that. to deliver services to another client in that category or another, not in a way that would breach any uniqueness or confidentiality obligations you have to the client you're working with, but in a way that is true, right? That it reflects the fact that this is our IP. This IP is yours. You get it when you pay us. This IP the agency retains. You get a right to use it when you pay us, but it's ours. It's never going to be owned by you. It's never going to be a work for hire by you. Sometimes you accomplish that with carve out language in the MSA itself. Sometimes you accomplish it with some additional addenda or agreements that run alongside of the MSA. But that's another common mistake is language that says everything we do for you is a work for hire. And no, it's not. And if it is, it's not a work for hire until and unless you've been completely paid for everything you've done for that client.
Yeah, I really like that, and it just brought up memories of, like, actually using that successfully in a previous life, and it's kind of powerful because it's like it's this very, kind of woo idea where it's like you own this idea. Like, you can turn over all the source files and all this other stuff that they need, but you have it, and, with bigger companies, that's the thing that I've seen kind of spook them the most, where it's like because nobody wants to be the one to breach the IP and to
Right.
create legal liability,
Right.
and so whatever the payment terms are, there is this power to, like, "No, this is ours until we're paid this amount that you said you'd pay us," right? So,
Yeah.
I like that a lot. I wanna get further into IP as a revenue stream. I think before we do, though, I wanna do a quick sidebar on the emotional element of this, and you probably have clients that handle this stuff really well, and others that are rushing through things. From your standpoint, what separates them emotionally, and how can people sort of, like, open up the patience to deal with these issues at the 99-yard line in the right way?
I think one thing that separates them emotionally is that the agencies who can navigate through this process with a little less urgency and a little bit more proactivity, if you will, have spent some time thinking systemically about their bucket list, if you will, their checklist, and then their benchmarks. And a great way to do this is to have thought through your own MSA toolkit. Every agency should have its own MSA and its own ride along documents and should have the default point of view that we paper our deals on our contract paper. And I know you have listeners who are going to roll their eyes when they listen to me just have said that because they work with large brands, they work with government agencies, they work with big nonprofits. Like, they're never going to sign our contract. We sign their contract all the time. And so whatever is in our document is really not something I'm going to lose a lot of sleep over. And I would challenge that thinking because I can tell you that if you have thought through everything that's important to the agency legally and financially, and that is reflected in your own version of the MSA, even if you're not using that document in every deal, it's your set of benchmarks against which you evaluate every contract that's presented to you as an agency. And so the agencies who are willing to do that, who are willing to think through their must haves, nice to haves, don't cares, are gonna do a more successful and frankly, a faster job of assessing and reviewing a client's contract when it's presented to them if they think that's the document that they need to sign. It's gonna make them more confident negotiators, and it's gonna make the process probably more profitable for them too because they're gonna catch things more quickly or they're gonna ask more questions that might lead to more favorable results, and so that's the emotional and mindset part is we have to think through this in advance and systemically, and we have to revisit that on a regular basis because there are legal issues that arise in the world that maybe didn't used to need to be reflected or acknowledged in our agreements, but now need to be, right?
Yeah, I have a couple questions there. I think the first is, I guess, like, actually more of an observation or guess. I would imagine that there's agencies that have to just burn their hand on the stove enough times to realize, like, we can't get too excited at the end of these deals. We need to get this in order first. Does that seem to reflect the clients that handle this better?
It does. Yeah, I can't think of a better way to put it than that. That is actually perfectly said, And I think also, we're in a transition phase right now, I think in agency land where legacy agency owners who were way more comfortable, relationship selling and relationship engaging with their clients didn't always feel like they even needed to have to worry about this stuff because there were fewer legal issues to arise, and also the strength of the relationship usually helped them overlook a lot of the other stuff. And they were making money lots of different ways, right? We all know what the traditional model of agency money making has been. So those folks are super hard to convince that just because you've never had anything blow up before doesn't mean that this is not a profitable exercise to prevent. I actually had somebody flag me down at a conference one time after I'd done a presentation, and he's like, "We don't believe in contracts." And I said, "Really?" I said, he's like, "Yeah, if a client doesn't want to do business with us anymore, we're not going to hold them, to any sort of contract." And I said, "Okay." I said, "So before you start doing work with the client, do you put together any sort of documentation of what you're going to be doing for them?" "Oh yeah. Yeah, we do that." Are the payment terms and the prices for what you're gonna do, are those in writing somewhere?" "Oh, yeah, of course." Then well, then you have a contract. I don't care what you're calling it. Um, you have an
You
arm's
just have a weak contract.
yeah,
Yeah.
yes, you maybe have an indefensible agreement, but you've got, an agreement that is a meeting of the minds that is reflected somewhere in writing on at least some of the terms of your business relationship. And so sometimes I think we get too caught up in the legal terminology and not really focused enough on the business result that these instruments are designed to help us achieve.
Yeah. And I agree, and it's kind of like this whole, like, "Oh, we have a relationship, so we don't need a contract," when the reality is you have a contract so that you can have a good relationship.
Yeah.
So there's this, and this is, you could probably broad frame this to all sorts of other situations in life, beyond legal ones, but it's like, it establishes what you're doing, what I'm doing, what's expected, so then you can build a relationship around that
Right.
without this sort of murkiness of what's going on.
Not only that, but it's a signal of common respect between brand and agency. First of all, I've already said the agency will never have more leverage than it has at this point in the relationship. But third of all, it changes the way you show up in the conversation with the agency to have pre-thought through and pre-documented these key business and legal terms of your relationship. You show up differently as an agency when the brand sees that you've actually been thoughtful about this. I've seen this time and time again, and it sets the tone for the relationship on a number of levels in a way that is advantageous to agencies.
Yeah, that makes sense. I want to talk a little bit about the who's doing what question, right? Because
Mhm.
in the biz dev process, many independent agencies are owner led.
Right.
Sometimes there's biz dev people. Sometimes you might even be involved yourself, getting pulled in fractionally.
Mhm.
Um, what do you see work the best in terms of, like, you get to the negotiation stage? Who should be involved then? What should owners be doing? Is there good cop, bad cop? Should owners be like, "Sorry, this is legal issue now," and keep their hands clean? Like,
Mhm.
what is there a structure to who's doing what that you've seen work the best?
Well, I mean, if I have to assign bad cop, I can tell you that that always is and or should be the lawyer involved in the negotiation. That's been my experience anyway, and that's fine. That's why we're there. But it's not our job to be bad cop. It's our job to make things possible, not to be obstructionists. But what I see work, and this can take many forms, but I pretty consistently have believed this throughout my career representing agencies, and I don't really feel any differently today is you have to centralize. And what do I mean by that? I believe in a centralized approach to engaging in the documentation with your clients, meaning you have agency standard agreements they may have to be tweaked here and there, but they are your starting point for every client negotiation. In other words, even if you know that it's a huge brand and they're probably not going to even look at you, you present it to them. That is part of your process. It's centralized. You know which document applies to which type of engagement or work scope. So, centralization of the process, centralization of the documentation, centralization of the person or people in your agency. And if you're very small, it's probably person. If you're a little bit bigger or more sizable, it should be the same people. It shouldn't be, 5 or 6 different account directors entering into contracts with 5 or 6. It should be centralized. I'm a huge believer in that because that is where you spot patterns. That's where you spot opportunities to make your documents better or notice that maybe you're consistently missing something because you're getting pushback a lot of times on a particular provision. So maybe you're not being practical. I don't know. Or you know when to tell your advisors that, hey, our document set as it is isn't working because these are the things we keep repeatedly getting, into debates about or hot water about, et cetera, et cetera. So
Yeah.
consistency, that's the huge thing.
Yeah, that makes a lot of sense. I think moving on to the IP stuff, I guess the first question is how, if at all, are you seeing AI affect the way agencies are thinking about IP and what they want to trademark and so on?
Yeah. I think a couple things about this. I think agencies historically, even before we were concerned about what AI means for IP rights, agencies historically undervalue IP, both the value of the IP they're creating for clients and their own IP, which we could spend an hour just talking about. And it's my favorite soapbox. So I'm not going to go there unless you ask me to. But AI means that we see questions arise in agency client relationships, agency vendor relationships, and agency freelancer or contractor relationships around these two issues. Who owns the work if AI is used in whole or in part to create it? And number two, who is going to be legally responsible if something goes sideways as a result of some piece of work that gets put out into the world and either has infringed on some third party's intellectual property rights or contains some sort of error or claim or law violation that was missed, but that AI assisted in making happen. So those are two issues around IP and liability in general, actually, that the presence and ubiquitousness of AI use is creating and that's gonna have to be dealt with contractually and in other ways between agencies and other parties.
Yeah, that makes sense. And I wish we had another hour for the full IP spiel, but
Yeah.
I guess with that said, for those that are thinking about this and thinking about trademarking, like what what are some of those examples or some, ideas for the value that's being left on the table when it comes to intellectual property?
Well, I think in terms of the value being left on the table, and this is really divorced from whether AI is used or isn't used. If you're creating systemic processes, systems, frameworks, um, anything that helps you develop specific insights or specific benefits to your clients repeatedly, you have something there, and it's something that is protectable, and it's something that is possibly monetizable separate and apart from your fee for service work for any specific client. We use just quickly, we use a triangle rubric to look to assess IP that an agency develops, and it's brand, content, and transactions. And so brand is obviously the source identifier of a good or a service. And usually agencies are creating brands for their clients' benefit, but there's benefits to creating brands for the agency's own use and to brand itself and its products and services. There's content, that's the stuff you're creating. That's the digital course you might create out of the intelligence you've gathered by doing the same type of project in the same type of industry over and over again. It's the keynote that is a seminal piece of thought leadership that should be protected in case it's appropriated by competitors or other folks in the industry without attributing or crediting you. It's the software you create. It's any original piece of content that can be protectable either by copyright or as a trade secret if you hold it close to your vest and keep it confidential. Then there's transactions real quickly, which refers to how you monetize the IP going out of the agency, but also documenting your rights to the stuff that any third party helps you create, like a contractor, a vendor, a freelancer, etc. So agencies just don't do this routinely, and it's you're leaving money on the table in most cases by not taking a breath. I think I shared this with you previously, Dan, that the only time I saw agencies take a breath around this was during the pandemic when they had less client work to worry about.
Yeah.
So it's like, what else can we do to create revenue? And that's when they that's when they started getting interested. Um, and how does that relate to AI? AI is showing us different ways of creating. It's also creating more real estate for us to infringe on other people's intellectual property. And so we have to be careful about that when we're creating deliverables for our clients' benefit. We have to be thoughtful and not dispense with our standard due diligence, like not skip the trademark search, not, skip the copyright or image search, and make certain we're not unlawfully using other people's IP, and then putting them into client deliverables that then go out into the world and get everybody in trouble, right?
Yeah, that makes sense, and whether AI is involved in this question or not, it doesn't really matter. It's mostly just back to the IP stuff, like, if I'm listening, maybe I'm an agency owner, I'm thinking like, the thing people pay us for is this work product that they own. And yeah, we have a process, and we have decks, and we have all this stuff, but I don't think it's that valuable. It's just sort of this thing that we have to do to create the work product. I guess, like, would you push back on that when you have owners express that sentiment? And if you, not to put you on the spot, but if you have any example or like an anonymized example that you can pull out of some, maybe something you identified or that an owner identified and developed into IP that became valuable, I'd love to dig into that a little bit.
Yeah, I mean, I have a lot of examples. One specifically I can think of that comes to mind because we're in such a heavy M&A period for small independent agencies is that owner that's maybe thinking about making an exit out of the fee for service agency business, but they have developed some proprietary methodology or IP that they want to continue to offer and on a consulting basis when they exit the agency. So they want to sell the agency and the book of client business, etc. But they want to still be able to use that original IP that they've created to monetize in a consulting environment, or maybe they want to white label it through other agencies because they no longer own one. Um, I've seen a number of owners in this situation, and so it becomes a deal point, in the M&A conversation. Um, I've seen other agencies create an entire monolith of income opportunities within their own industry with the IP they've created. They not only have an agency themselves, but the intelligence that they've created, the systems they've created have resulted in community building and also licensing opportunities of that IP that sometimes ride along with a client engagement, but also have evolved into certification opportunities, resale opportunities from other agencies. And so that owner is sitting on not only a pile of client revenue, but also a pile of potential certification revenue and community revenue via memberships and things like that, separate and apart from the agency's, main business. So those are the two examples that come top of mind. And I've seen other examples of those same scenarios multiple occasions.
Yeah, that makes sense, and I think, like, with all the leverage from technology, there's so many more opportunities for doing that than there used to be, so
Yeah.
that's great. To bounce around a little bit, one thing that I forgot to ask you earlier when we were talking about contracts is you wrote this piece, if I have this right, about rapid responses to these common scenarios, so we might be retreading things you talked about, but I love to talk about that, the client demands X, here's what you can do. Can you go over a few of those that you covered?
Yeah. You wanna hit me with any specific ones, or you want me to
No, just kind of like the
spitball
rap
'em?
the general. if this then that sort of thing, which
Yeah.
is probably coming up a lot. Yeah.
I think that, all right, if this then that. We talked about exclusivity, so let's talk a little bit about examples there. The client has come to you and they don't want you working with any competing organization, and they want that covenant to last, a year after you've stopped working together, because they want the afterburn of all the good work you've done for them, and they don't want you, taking your talents to a competitor. So what do you do there? Well, you could say no entirely. We refuse to entertain it at all. Most agencies won't do that, and I respect that. That's a business decision that's defendable. So what can you do instead? Well, you can limit the exclusivity to a certain number of competing companies. You can limit the exclusivity to specific product categories. Um, Within those competing companies, which goes even narrower. You can limit that exclusivity to only the term of the engagement or the first X months of the engagement. So there's things you can definitely do to take the teeth out of that ask and make it more palatable to you and still, be able to process forward with the client who you really want to work with. So that's one.
Yeah. That's great.
Secondly, indemnification and liability. How do you determine who's going to be liable? So the standard ask in a client provided agreement, you're going to hold us harmless agency for basically anything that you do negligently or any harm that you cause us as a result of the work you create for us, including IP infringement, including getting us into regulatory trouble, because you breached a data privacy rule, or you infringed on somebody's IP, or you put a claim in the ads you created that wasn't correct, or etc. So you're not going to get away with saying no, we're not responsible for any of that. But how do you react quickly to that? There's a few things you can do. You can agree to limit liability only to the extent of the particular project you're working on, the time or the scope of work that you've entered into for that particular piece of work. You can I'm stair stepping in here, but you can limit your liability to the value of the entire client engagement, all the fees that have been paid to you from that client. You can also limit your liability to whatever your insurance policy liability limits are, and that assumes you've got a good insurance stack in place with general liability, errors and omissions, cyber, etc. So you could stair step the liability rather than just agreeing to a blanket term.
Yeah.
Um,
That's great.
IP would be a third example, and that is, everything you do for us from the time your employees think about it to the time you deliver a piece of work to us is ours. It's a work for hire and we own it forever. Okay, well, you have, some work to do there, obviously, based on what we just said, but your response back is a combination of these assets are yours when you pay, these assets will always be ours, but you have a license to use them, and we'll govern the terms of the license based upon some of the other things that are in our relationship. Or, you know, just no. We're not agreeing to that at all. So those are three examples of rapid responses on issues that we see on repeat.
Yeah, and at the very least, it's you get that when you pay us, if nothing else.
100%.
So,
Yeah. Yeah.
yeah, that makes sense. And I think another thing to point out is, like, there's probably owners that agree or are nodding their heads to this, and then they get to the 99-yard line after a long sales process, and they're like, "Yeah, well, what's it really worth to us to be able to take on another XYZ client? Like, we'll give up exclusivity and so on." And they're putting dollars and cents, and they're emotionally affected and wanna get it over the line. But there's an element of, like, you're setting the frame for the engagement as well and for
Mhm.
what the other party thinks they can get away with and so on. So,
It's not always easy to play the long game when you're in a biz dev situation. I get it. Everybody's excited. Not only your accountant, to get the check, but your teams are excited. They wanna get I mean, you've either won a pitch or you've been picked, you've gotten the rose, and it's all systems go, and everybody's already thinking about the opportunities that you could explore together. And then it's a drag down, right? Because of, having to get everything squared away in writing. But you have to play the long game, and this is a long game, and playing the long game is what makes the agency more money in the long run.
Yeah, and, back to the it's easier said than done when you're in the situation, it's hard to push back and all that.
Yeah.
So I'd love to ask you, like, you probably have clients that are worried about pushing back and standing their ground in these places because 'cause they're scared the deal's gonna blow up, and I'm sure it does happen, but how often does that actually happen at that once it's to that level?
I gotta tell you, just about never. I can maybe think of one deal that didn't move forward, because conversations that surfaced during the negotiating process just unveiled sort of some values disconnects between the parties. Um, but I've been doing this a long time, and honestly, I don't see deals go sideways. And you can always retreat to the center ground of agreeing to what a brand has asked for. But and so that's not a good reason for not presenting a reasonable business case for why you're asking for what is fair to you and profitable enough to you, as an agency. And that's your job as an agency leader, or it's a job that's been delegated to you, as someone who's in charge of business development for an agency is, um, you know, quick pops are fun, but if you if you play at the margins indefinitely, or you are scattershot about the way that you look at this, and I acknowledge this is not the sexy part of running an agency. This is not why most agency owners, go into the office or open their computer every day. They don't love this part of it, but they certainly love being profitable. And getting this ingrained into your, um, SOPs for doing business and socializing this with your leadership team makes the agency stronger and more profitable and uses the legal part of your foundation as a way to partially do that.
Yeah, there you go, and I think that's really powerful, the fact that these deals almost never go sideways at that
No.
point once they've gotten that far, and I think that's a great note to end on, which is about, setting up these systems, holding your ground, and making the right business case. So with that, Sharon, always a pleasure. Where could people go to follow what you're up to and get in touch and get all of their legal affairs in order?
Thanks, Dan. I always love talking with you. You ask great questions. So the firm is Torek Law, and again, we do business in the agency world as legal and creative. So you can reach us at legalandcreative.com. I'm active on LinkedIn. It's Toerek. Or tune into The Innovative Agency, which is our podcast, with agency leaders and agency adjacent experts. Not about the law, by the way, but about innovation and sort of looking around the corner, in agency land at, what's next. And so you can find us there too.
Cool, and I'm stoked to be a guest, at some point soon, depending on when
You
this comes
are
out.
going to be an encore guest in about 2 weeks on the show. And so we're doing a bit of a crossover here. So come see Dan get grilled by
Perfect.
me on
Yeah.
his areas, many areas of agency expertise. Looking forward
Yeah,
to
it'll basically be a deposition and everything.
it. Well, you know how to be a witness because your parents are lawyers, or at least one of them is.
Yeah, or one of them is, yeah, very, very so Sharon, always a pleasure. Thank you so much.
Thanks, Dan.
Yeah.